Chapter 1. Legal Self-Help. Outside sources are underlined in blue text. Forms available in our Forms package are underlined in red text. Links to each are below this video. Let me preface this by saying that this chapter is for the most part a summary of this entire e-course, all 17 chapters. It's very heady and jammed with information. Think of it as an overview of what is yet to come in a more detailed, focused manner. We are intimidated by our legal problems. That's all there is to it. And we pay a high price by extricating them from our lives and handing them over to a lawyer. Consider some of the ways we respond to problems in other areas of life. How do we deal with emotional problems? Do we hand the problem over to a therapist and say, "Handle this for me and let me know when it's over"? No. We spend weeks, sometimes months, pondering, discussing, and dealing with the problem, sometimes with the assistance of a therapist. Often, we buy books, attend seminars, and explore all effective tools for problem solving. How do we respond to medical difficulties? Suppose you get the flu. Do you rely on your doctor for relief? No? You have chicken soup, take 2 aspirin, and go to bed. You give your body a rest. What about more chronic ailments, such as back pain? Would you depend solely on your medical practitioner? Knowing yourself, your limitations and symptoms better than anyone, you research the various solutions and work with the medical practitioner to bring about changes. If we can be responsible for our medical and emotional woes, why avoid legal predicaments? Faced with emotional or medical problems, we seem to realize that self-help is an important component of solving the problem. Why then do we respond so differently to legal problems? It's obvious. We become intimidated and overwhelmed. We have a mindset that legal issues are just beyond our comprehension. The dump truck syndrome. Instead of meeting our legal problem head-on and seeking a productive solution, we either pretend it's not there or we gather the evidence and drop it off at the first law office and plop down a hearty retainer, saying, "Here. Fix it and let me know when it's over." Saving lawyer time is in your best interest. Don't make the mistake of avoiding participation in your case. An attorney's services are expensive. Remember how long it took you to read the stack you just dumped on the lawyer's desk? Well, for the lawyer's scrupulous review, multiply that by 10. It becomes apparent that saving lawyer time is in your best interest. How did we get so disempowered? It began centuries ago when we were fooled into thinking the legal system is out of reach to ordinary folk. A privileged legal forum arose, using Latin terminology, complex rules, and warlike tactics. This ivory tower was accessible only by scholarly doctors of jurisprudence. These first attorneys positioned themselves on pedestals and constructed the legal arena beyond the reach of the layperson. Attorneys were assured large fees and rising power. What's wrong with the public courts? For decades, people have complained about the public court system. They report investing substantial sums to obtain justice, but their results don't justify the expense. They feel unheard and ripped off by a complicated legal system and by attorneys who charge too much. The judgments handed down are appalling, which is often the case with publicly funded platforms. And handed down is precisely the right terminology. You sit there powerless for the most part, waiting for the next round to dole out the next consequence. The legal participants, the very people most interested in their disputes, had very little to do with their legal cases. Attorneys scoop up the problems, dress them with legal jargon, and submit them for legal determination. Then in comes Lady Justice to pick a winner and loser. The result: the disputing parties are intimidated and often outraged by the process. The fact is, most people are not heard, the court system is unduly complicated, and attorneys are expensive and often motivated by greed. How much justice can you afford? Often, the result of your court case depends upon the work quality of the attorney you hire, and the amount of time assigned to your matter. Each factor depends on the supply of money you can spend on the case. If you have a sizable bankroll, you can hire the best attorneys and conduct voluminous investigations. You can literally outpaper your opponent and win a case not on its merits, but upon how much time your attorney invests. Understandably, this is a popular strategy in the legal community. Is it right that the winner is the one who has the most resources? Should our system operate this way? Should we do something to change it? This lopsided quality prompted British novelist William McIlvanney to write, "Who thinks the law has anything to do with justice? It's what we have because we can't have justice. Time for a change." These arrogant ways and cryptically carved customs have held reign far too long. Especially now in the culture of transparency and self-help, customs are at long last giving way to more democratic methods. Enter private alternative dispute resolution. Now you have the choice to go with the public court system or with private alternative dispute resolution, consisting of mediation and arbitration. Decisions in both sectors are given equal weight, with arbitration judgments enforceable in the same way as court judgments. However, there is an important difference in these forums. Anyone can bring a dispute to the public courts, while you must have an agreement signed by all parties consenting to alternative dispute resolution to access this private sector. Our chapters on ADR coming up will show you exactly how to obtain these agreements. Creating a parallel private system was a step in the right direction, but it wasn't enough. We've become a country of people who want to be hands-on when it comes to important life situations. We needed a system where disputing parties could involve themselves more in the legal process, in a less legal way, something more hands-on. Enter the coronavirus. The coronavirus was just the thing to serve the double whammy that finally caused the legal system to embrace the needs of the legal self-helper. When the attorneys, judges, parties, and witnesses could not be in one another's presence, something big has got to give. And it did. Zoom became the answer for so many businesses and social platforms. For the legal system, where time is of the essence and in-person appearance was necessary, it was an obvious answer. Now we have robust online platforms for mediation, arbitration, small claims court, and sometimes even the upper civil court. The unintended beneficiary of all of this is you, the self-represented party who had difficulty maneuvering in complex systems that required personal appearance and sophisticated choreography. A new way for the legal self-helper. At long last, the dream of the legal self-helper has come true. Not only has ADR put legal solution in the grasp of the self-represented, but the courts are also doing it big time. Let's take a moment to again summarize our two dispute resolution systems before we delve into the more modern tools available. First, there is ADR, a private dispute resolution system which for admission requires the agreement of all parties. You are fortunate if you have, or can obtain, a written agreement with your adversaries to resolve your dispute in user-friendly alternative dispute resolution. Most ADR agreements exclude disputes that come within the small claims court limits. These lower-value cases are excluded from alternative dispute resolution since the small claims court is different from the rest of the public court system. It's quick, it's easy, it works. Some states even forbid attorney representation. If you don't have an ADR agreement, your dispute resolution option is the public civil courts, where filing suit is a matter of public right. Civil court cases are divided into court types depending on how much money they are worth. Small claims court handles cases valued up to your state's small claims court limit. The upper civil courts, which are also defined by case value, handles cases above the small claims court limit. Depending on your state, the names for these upper civil court systems are district court, circuit court, or superior court. The Pro Se Litigants tools. The Pro Se Litigants toolchest now consists of legal analysis with apps such as the Lawsuit Analyzer, mediation and arbitration customization, remote platforms for online proceedings, online case prep and filing, small claims advisors. With these tools, the legal self-helper can take a hands-on approach to legal problems. If someone else, like your attorney, is put in charge of your dispute, you've lost control of your costs. You've also lost your ability to intelligently resolve the dispute before attorneys are involved and it becomes a major battle. Since you have chosen to take this course, you are making the decision to take the bull by the horns by utilizing these many tools now available. Legal analysis. The Lawsuit Analysis app provides the missing piece, legal analysis. This app takes you through the elements of your case, provides you with legal analysis, evaluates the feasibility of your case and its collectability, assesses your legal options and the appropriate forum for your case, and makes recommendations as to how to proceed. Let's now explore the two platforms available to you once you decide to move ahead with your dispute. First, we'll look at Private Alternative Dispute Resolution, known as ADR. Then we will focus on the public court system. Remember, this is just a quick summary since there are a total of 16 more chapters that delve deeply into each. Mediation and arbitration customization. Since ADR is your own platform, agreed to by you and your adversaries, you are in the land of all things possible, well, nearly all. In this free-form environment, unbounded by rigid court rules, you can customize your mediations and arbitrations to better suit your needs with self-representation agreements, limited hearing durations, online platforms, limited discovery and arbitration, document-only arbitration, and so much more. When you sign up for ADR, you've taken an important step, but don't stop there. Customize your proceeding with choices that streamline the process and propel you to the finish line in a constructive way. If you have an existing ADR agreement, you can still customize it if all parties agree. All of this will be addressed in later chapters on these subjects, but here are some options to consider. Your creative mind can come up with many more. 1. To first engage in automated online blind bidding. 2. To engage in mediation before arbitration. 3. The choice of mediation or arbitration provider. 4. The parties will be self-represented. 5. The hearing duration will be limited. 6. The choice of mediation or arbitration as document-only, entirely online, entirely in person, a hybrid. 7. At arbitration, the winning party will pay the loser's attorney fees and costs. 8. At arbitration, the winning party will pay the loser's fees and costs. 9. At arbitration, there will be limited or no discovery. 10. At arbitration, revising the rules of the arbitration provider. Let's explore each option. Option 1. To first engage in automated online blind bidding. Prior to filing suit or initiating ADR, the parties agree to proceed to automated online blind bidding, described below. Option 2. To engage in mediation before arbitration. Why take your dispute into the arbitration arena where a judgment will be imposed when it can very likely be resolved at mediation, which has an 85% success rate? Option 3. Choose the mediation and/or arbitration provider. There are many ADR providers, including long-standing frontrunners such as Judicial Arbitration and Mediation and the American Arbitration Association. Perform an internet search of mediation arbitration providers to locate more. Option 4. The parties agree to be self-represented. How would you like to get it over with without attorneys? With a third-person mediator or arbitrator, you have a built-in attorney. Perhaps hiring an attorney of your own is redundant. Smart cookie tip. Sign a self-representation agreement with your adversary so you will be on equal footing. Option 5. Limit the duration of the proceedings. ADR, especially arbitration, can expand into full-blown mini-trials unless contained. Limiting the duration of the proceedings requires the parties and the mediator, arbitrator to use the time wisely. Remember, the reason you are in ADR is to get it over with soon and with minimum expense and stress. Smart cookie tip. Make sure the mediator, arbitrator apportions the time evenly, understanding their job to also to be a time balancer between the parties. Option 6. Specify that the proceedings are to be document-only, online, in person, or a hybrid. If a pre-dispute or post-dispute ADR agreement specifies mediation and/or arbitration as your dispute resolution forum, all 4 options should be available to you. But if the provision does not specify which, the choice will be up to disputing parties, which is never ideal. It is therefore best to make this choice in the ADR agreement itself. You can always amend the ADR agreement with the consent of all disputing parties. If not specified, a brief pre-hearing session with the mediator or arbitrator can be set up to elect which platform to use. These platforms are described in detail below and in subsequent chapters. Option 7. Agree that at arbitration, the winning party will pay the loser's attorney fees and costs. Assuming you do not already have a written agreement that covers attorney fees, now is the time to consider the subject. Even if an existing agreement does include this provision, it can be revised or removed with all parties' agreement. The parties need to feel they each have a good case or defense to agree to a provision like this now. Losing a case and having to pay your adversary's costs to fight you can be a very challenging blow both to the ego and the pocketbook. Assess exposure very carefully. Smart cookie tip. You can also tailor this provision to limit exposure, such as up to a maximum dollar amount. Option 8. Agree that in arbitration, the winning party will pay the arbitrator fees, including administration fees. If you have not limited the duration of the arbitration, you could face a sizable sum here, likely much less than attorney fees, but still something to carefully assess. Option 9. Agree at arbitration to limit discovery or to have no discovery. This is something very important but difficult for a layperson to assess. In later chapters we will describe the forms of discovery so you can make wise decisions to limit discovery to only what is absolutely necessary in your case, or none at all. The arbitration chapter delves into this very important provision more deeply. Option 10. Agree that at arbitration to revise the rules of the arbitration provider. Read the rules of the arbitration provider selected. With the agreement of all parties, some of those rules can be revised. The name of the game is customize, customize, customize. Don't blindly walk into your proceedings without setting the stage with the many options available. You wouldn't walk into an important business meeting you were leading without an agenda. Well, this is an important business meeting. Carefully select the options best for you, and for your adversary since you will need their agreement. Remember, ADR is not the rigid court system where rules of engagement are etched in stone. ADR is the way for modern disputing parties to intelligently direct their dispute. If you already have an ADR agreement and it does not include options like those listed above, they can be added now if all parties agree. Our options addendum to ADR agreements includes a list of options which are discussed more deeply in other chapters. Remote platforms for online proceedings. The legal self-helper now also has robust online platforms referred to as online dispute resolution to allow the parties to appear remotely for mediations, arbitrations, and some small claims proceedings, thereby removing both the intimidation and inconvenience factors associated with in-person hearings and to make it possible for you to avoid the scary courtroom atmosphere. There is also a new platform which has emerged as a quick and easy way for disputing parties to bid into a settlement. The process is still in the formative stages and has not adopted a common name yet. It has been referred to as automated online blind bidding, online dispute resolution, and blind bidding. Online document-only arbitration, which would preclude oral arguments, has also become more popular especially for the self-represented, allowing them to avoid oral legal argument and focus only on the written word. Online mediation and arbitration. There are 2 ways to participate in audiovisual ADR: in person with the parties present all together in person, and online with the parties present online. There is also a hybrid where some parties are personally present and some are online, or some of the proceedings are online and others are in person. Nowadays, our disputes have more modern solutions with impersonal, technology-based platforms, making ADR far more convenient and accessible. Smart cookie tip. Judicial Arbitration and Mediation provides a 2-minute video online. How does virtual mediation and arbitration work? that describes the characteristics of these new online platforms. Smart Cookie Tip. If your ADR agreement includes both mediation and arbitration, you can always choose in person for one and online for the other. Our chapters on mediation and arbitration outline the advantages and disadvantages of online ADR so you can make the best choice for your proceeding. Automated online blind bidding, aka blind bidding. Automated online blind bidding is a novel new online platform like an auction where the prize is settlement. It's quick, it's inexpensive, it's easy, and there is nothing personal about it, such a positive when disputing parties are at odds. This type of negotiation, referred to as blind bidding, is available to anyone wanting to resolve a legal dispute. The blind bidding process could be just the thing to get your dispute resolved at the beginning, in the middle, at the end, where other processes have failed. It's really worth a try. What's there to lose? And it's do-it-yourself where disputing parties can do it without attorneys, mediators, arbitrators, or the court. The usual paraphernalia associated with a legal solution is absent. No presenting your case, posturing, waiting around while everybody gets a turn. All that's needed is you and your adversaries online, not even at the same time, hopefully motivated to dispose of this mess that will undoubtedly disrupt your peace of mind. It's more like a game that doesn't require much stratagem other than arriving at price points. It's not heady, like chess. It's more like bingo. When the numbers line up, you've got a winner. So simple, yet quite effective since it could easily end the dispute that's been your number one stressor for years, or could be. An ADR agreement option for automated online blind bidding. Automated online blind bidding is one of the optional provisions contained in our form ADR agreements where in advance of any other proceedings the parties can agree to give automated online blind bidding a try. This is a sample provision. Automated online blind bidding. Within 30 days of the date of this agreement, the parties agree to submit their dispute to automated online blind bidding. If settlement is not reached, the parties shall proceed to the next step under this agreement. Providers. Since automated online blind bidding is relatively new for legal disputes, there are only a few private and court-sponsored providers. We expect new companies to spring up in the near future. Private providers. SmartSettle1.com is a negotiation app utilizing sophisticated algorithms, including visual blind bidding, for two-party negotiations. At the end of bidding, the platform chooses the settlement amount, which is documented by a certified settlement agreement. Perform an internet search of automated dispute negotiation or blind bidding dispute negotiation to locate other providers. Court-annexed providers. Automated online blind bidding is new to the courts also. They also see its advantage since it is being implemented in some locales to assist primarily self-represented parties in small claims cases. Hopefully in the future it will be used in the upper civil courts also, or anytime there is a disagreement between parties that can be resolved by the payment of money. A 4-minute video prepared by the New York courts explains the automated negotiation process, which they refer to as online dispute resolution. Remember, this is New York. The laws of your state could differ, as well as the small claims court value limits. Be sure to watch this video. It illustrates exactly how the court-affiliated version of the process works. It's different from other online dispute resolution methods in that it is like texting settlement numbers with your adversary until you get to a midpoint when settlement is reached. Some platforms also allow you to pull in a mediator if you and your adversary have hit a wall. The courts that do make the negotiation process automatically available make it readily accessible to you. For instance, in some California small claims courts, once the court receives the email address of the parties, an invitation to online negotiation is sent to each. The parties negotiate via an online chat platform, like texting, and if they feel a mediator is needed, one is invited to the platform. If an agreement is reached before your court date, the case is dismissed. Document-only arbitration. Document-only arbitration is the same as other proceedings. It just excludes oral hearings. Like online proceedings, the document-only process was infrequently used before the coronavirus, during which we became more technology-based, which made it possible for the parties to avoid in-person proceedings. This atmosphere opened a whole new paradigm for document-only proceedings. The written documents may include contracts between the parties, declarations made under penalty of perjury, other evidentiary submissions, and memoranda of points of law. The rules of the arbitration provider will provide guidelines defining documents permitted. These proceedings, which exclude the audiovisual element, streamline the proceedings considerably and make room for the self-represented party to step up to the bar. Mid to low-value cases are prime for document-only arbitration. Some ADR providers like the American Arbitration Association sort their arbitration cases by value, where those valued at $75,000 or less follow expedited arbitration rules, and those valued at $25,000 or less are routed to a document-only format. These value markers change frequently, so be sure to double-check. Smart cookie tip. You and your disputing party can opt for document-only arbitration regardless of whether your case falls into those price ranges. Online case prep and filing for the public court system. The private ADR system has provided an online case filing platform for a long time. But, for the courts, this is new. The dream of the legal helper has finally become available in many state courts where there are now portals for the self-represented to prepare, file and even serve their lawsuits, with interviews to help with the process. Smart cookie tip. As of this writing, it is nearly impossible to locate other resources that will undoubtedly filter into the mainstream over time. But we can point you there. Go to Guide and File to see if this platform has reached your state. This is their marketing piece. If you are representing yourself in court, you can now create and file many court forms on the internet. Like popular tax preparation software, you will be guided through a series of questions. Your answers will help automatically prepare and file your court forms online. It really doesn't get much better than this. It's not yet set up to handle a lawsuit in the upper civil courts, see the upper civil courts chapters, but it will give you access to the small claims court and various other legal actions such as divorce, evictions, restraining orders, guardianship, etc. The motto of this new platform is, "Every single person, as an American, should have a right and access to court." Odyssey Guide and File will afford pro se litigants the opportunity to have their day in court. Now pro se, self-represented, litigants finally have access to the public court system like never before. Small Claims Court and its free advisors. Small Claims Court is really the people's court. It was made for quick and easy solution without all the complexities of the upper civil courts, which we refer to as the House of Horrors. Now that claimants and respondents alike can prepare and file their claims and responses online, the legal self-helper has heightened motivation to fit their case in the people's court. Each state has a different small claims court limit, meaning the maximum amount a user can recover. The limit amount as of this writing is as low as $3,000 and as high as $25,000, depending on which state your claim must be brought in. If your claim is more than the limit amount, you can still bring it in small claims. You just must reduce the amount you are asking. Seriously consider doing this since the House of Horrors will be your forum unless you have an arbitration agreement. Smart cookie tip. The chapter When and Where to File My Lawsuit helps you determine which state, county, and civil court to file your case in. You might find you have a choice of states to file in, allowing you to choose a state that has a higher limit and appear at the hearing remotely. Do everything you can to squeeze your case into small claims court just to avoid the upper civil courts and the litigation frenzy, described in later chapters, that accompanies upper civil court. Most state courts also either have voluntary or required mediation prior to having your case being heard. See the Small Claims Court chapter for more information. Some courts are also starting to offer online pre-hearing automated negotiation, giving the parties one more chance to hammer out a settlement. It's working well because it provides an important buffer to in-person negotiation. Before filing your small claims action, consult with the perfectly free small claims advisor by either calling the small claims court that will be the forum for your dispute, or better yet, search online for their website. Most counties have these advisors. Heading to the upper civil court. If all else fails and your forum is the upper civil courts, the upper civil court chapters guide you through the obstacle course of the House of Horrors. This is your dispute and your life. You can only make an intelligent plan that conforms to your persona and your budget if you understand the playing field. Assessing your situation. Let's summarize. If you have an ADR agreement, this includes any written contract with your adversary that includes an ADR provision, and it includes arbitration if mediation is unsuccessful, you're in good shape. If you just have a mediation agreement and not arbitration, you are still headed for the upper courts unless quick and easy small claims court is your forum. If your case value exceeds the small claims limit in your state and you don't want to reduce your case value, you will have to access the upper civil courts unless ADR has been agreed to. If Lawsuit Analyzer has identified the forum for your dispute as the upper civil courts, do everything you can to reroute it. The upper civil courts chapters contain every imaginable way to do this. Diverting a dispute headed for the upper civil courts. The upper civil courts nationwide are so overbooked and underfunded that most cases are not heard for many years after a dispute arises. By the time the case is heard, nobody has a clear recollection of the facts. But the litigants vividly remember the excessive time, stress, and money they spent getting there. Apply logical thinking. Think about it. If the upper civil courts can't do their job timely or adequately, why give them your case? Why spend years in the litigation frenzy seeking it? Why not get justice now, quickly, and inexpensively? This is the primary reason to seriously consider diverting your case to ADR or small claims court. Court-ordered ADR. Acknowledging these shortcomings, the upper civil courts nationwide now set hearings just after cases are filed for the purpose of referring litigants to mediation. And, if the parties agree, also to binding arbitration if mediation is unsuccessful. If they do not agree to arbitration and mediation fails, they return to the beleaguered court system. Apply logical thinking again. Ask yourself, why go to the trouble of filing a lawsuit in the upper civil courts when the court is just going to refer you to ADR? You respond, I don't have a signed agreement for ADR and my case is worth more than the small claims court limit. The upper civil courts chapters are loaded with ways to do this. Diversion to ADR. Treat this like a business matter. Go directly to your opponent, make them aware of the above information and ask for their agreement to bypass the court system. If they agree, prepare an ADR agreement and seriously consider choosing the convenience of online ADR. Use your second license to our Lawsuit Analyzer app to choose alternative dispute resolution. Your case results will increase considerably. Diversion to small claims court. Apply logical thinking one more time. If our upper civil courts are so overbooked and underfunded that they can't adequately do their job, why give it your case? Then, ask yourself this. Should I again consider giving up some of my claim to fit into the small claims court system? Use your second license to our Lawsuit Analyzer app to choose the small claims option by reducing your claim. Again, your results will increase considerably as you will detour out of the House of Horrors. Stuck in the upper courts. Entering the upper civil courts is very serious business. Be forewarned, you really don't want to get stuck in the House of Horrors without an attorney, unless you and your adversary agree not to be represented by counsel. Hiring an attorney. Will you hire an attorney to represent you, or will you represent yourself? You need to recognize what lies ahead, even if you're planning on hiring an attorney. Let's change that to, you need to recognize what is ahead, especially if you're planning on hiring an attorney. This course is your mini legal education. It is the closest e-course you will find to understanding legal liability and how the legal systems work. When you work your dispute through Lawsuit Analyzer, you identify whether you have an attorney fee provision which would entitle you to attorney fees if you win. If so, and if you have a high feasibility rating, having attorney representation is logical. But, if you lose the case, you could end up paying your adversary's attorney fees. This double-edged sword is explored in more detail in subsequent chapters. If your decision is to hire an attorney, read their reviews by prior clients, and if the reviews are positive, interview your candidates carefully with our chapter Hiring an Attorney. Do it with teamwork in mind. You will participate with this attorney in achieving your legal solution. Client participation is very important as you make decisions to limit discovery. Continually consider settlement and diversion into ADR if the upper courts is your forum. Keep fees and costs down. Re-evaluate both case value and feasibility as the case progresses. It is imperative to begin case planning before any attorney engagement agreement is signed, especially a contingent fee arrangement, since the case you plan together should take much less work than when the attorney makes all the decisions. With your plan and armed with this course, your case may very well be truncated by ADR or settlement. Just because you were unsuccessful diverting your case previously, doesn't mean it won't divert when you set up your armory and file suit. Your plan is to re-evaluate and reposition at every juncture. Even though so far you have not been able to reach a settlement, when your lawsuit is filed or a deposition is scheduled, a whole new opportunity for settlement or diversion to ADR is possible. Also keep in mind that a contingent fee arrangement is really a conflict of interest for your attorney, but somehow accepted in the legal industry, since the attorney wants to earn as much as possible and is likely indoctrinated to the litigation frenzy. All of this and much more is addressed in our Hiring an Attorney chapter. Let us help you help yourself. This course, the Lawsuit Analyzer app, and our website, lawsuitanalysis.com, is all about helping the legal self-helper, whether that takes the form of self-representation or partnering with an attorney. Focus, feel empowered, know that with this course and the resources on our website, lawsuitanalysis.com, you have an up-to-date central place to go to for support. We have your back.